I call Sarah Dowie.
Thank you, Mr Speaker, for the opportunity to again speak on this Statutes Amendment Bill. It seems only like yesterday that we were enjoying musings of the second reading, and we've just come out of committee and now we get to debate this bill again. And picking up from my colleague's statement, Mr Hudson, he was going to refrain from talking about the positives and the benefits of having omnibus bills, but I can't help it either. They are a fantastic vehicle for expediting the legislative programme, and I am fully in support of these bills. Quite often from my colleagues, I am teased for the wide-ranging bills that and matters that the Government Administration Committee hear, but I am thrilled to sit on that committee. The very nature of it being wide-ranging in issues makes it fascinating, and I believe that the people that sit on that committee definitely have skills that they are able to look at a wide range of acts, in particular with respect to this bill, and understand them and move them forward, shepherd them through the House effectively. So I appreciate sitting on the Government Administration Committee. I appreciate its breadth of topics, and I appreciate being able to talk and debate this bill, because it is important to update the various legislation that needs updating, and to put it into plain, simple English so that all of the public understand the laws in which they are governed by. And I think the Select Committee process as well, shepherding this bill through the process, is extremely important. And I know that the committee, I wasn't fortunate enough to sit on the committee when they heard the submissions, but I understand that there were a whole 4 submitters, and we shouldn't, take that as an indication that this bill is not significant. Those 4 submitters showed an interest in this bill and the importance of it. They were very good submissions, and in fact, I understand that there was one submitter, the Law for Change Otago, and they were a group of students and young professionals interested in public law. And they actually gave a detailed 15-page submission which highlighted the potential for semantic misunderstandings in the bill. And I am pleased that this Parliament and this process can give that opportunity to our young law students to involve themselves in lawmaking. And I'm sure that they've enjoyed that process and have moved on to fruitful careers in the law, and that this process has enabled them to widen their knowledge on public law and omnibus bills. So moving on to some of the provisions in the bill, I'd like to talk about the Sale and Supply of Alcohol Act 2012 and the amendments that this bill makes to it. And in clause 88 of the bill, it clarifies that the period for appealing against elements of a provisional local alcohol policy runs from the notification of that provisional policy and not from the notification of the original draft policy. And of course, this change relates to natural justice. You're giving a period for people to comment on and submit on from the version of the alcohol policy that is most likely to be passed. And that's only fair, and the mind boggles really that those changes needed to be brought into effect. But sometimes these technical difficulties follow through, into the bills or the acts, and we need to update them so that they are more meaningful in real life terms. Clause 89 of the bill replaces the incorrect reference to a draft policy with reference to a provisional policy, and that simply takes into account the transitional processes there, and it simply makes sense. Whereas Clause 90 of the bill with respect to the Sale and Supply of Alcohol Act clarifies that objections to the granting of licences are limited to the suitability of the applicant. In the case of an application for a licence that is of the same kind and is subject to the same conditions as the current licence for the premises. And that's fair enough. When there's no terms of that licence changing and that they've been thoroughly considered in the first place, but the licensee is changing, then that expedites the process and is a fair enough consideration to consider the suitability of the applicant. Clause 91 of the bill clarifies that a licensing authority as well as a licensing committee has to state a date for the expiry of the licence if a renewal is refused. Again, that sets clear parameters. It reverts back to natural justice premises and sets a clear expectation as to what is expected of that licensee and when they are to cease operations. Clause 92 amends the heading to provide a fuller indication of the contents of the section, which is simply fair enough. And finally, Clause 93 of this omnibus bill with respect to the Sale and Supply of Alcohol Act clarifies that electors of trustees of community trusts must reside in the trust district. And that is absolutely fair enough. It is the electors within the district that know about their community. They are focused on their community needs, and therefore they are in the best position to elect those trustees. And of course, it wouldn't be cricket if I didn't bring that back to my electorate and to Invercargill and talk about the Community Trust of Southland, which is an absolutely fantastic organisation that supports our community so wonderfully. And to end with, I would like to simply highlight some of the projects that they are involved in. If it wasn't for the Community Trust of Southland, we wouldn't have the Velodrome, a world-class facility to encourage young cyclists and to enjoy the sport of cycling. Thank you, Mr. Speaker.
The Honourable Ruth Dyson.
I'm sure this has got to be peak viewing time.